SJC-13439 in the matter of Francis R. Mason.
Okay, Attorney Feminari.
Thank you, Chief Justice Budd, and may it please the Court. Good morning, Your Honors. Assistant Attorney General Christine Feminari, on behalf of the appellant, the Massachusetts Executive Office of Health and Human Services, MassHealth. MassHealth asked the Court to reverse the decision of the probate court below and find the following. First, that a lien imposed by MassHealth on the real property of a MassHealth beneficiary does not automatically expire upon that beneficiary's death. And second, that the Massachusetts Uniform Probate Code, or MUPC's, 3-year ultimate time limit does not apply retroactively to bar a claim brought against the estate of an individual who died prior to the MUPC's effective date. Beginning with the first issue, the probate court erred in its interpretation when it concluded that the lien expires upon death. In its interpretation, the probate court failed to consider the ordinary way in which statutory liens operate.
Isn't the purpose of it, it has a specific purpose that you put this lien on in case the house is sold while the person is in the facility, right? So it serves a distinct purpose, right?
That's one purpose of the lien, Your Honor, yes. Another purpose.
Go ahead.
I'm sorry, Your Honor.
No,
Another purpose of the lien is to secure the right of MassHealth to recover after the individual's death.
But they have the right to recover after the individual's death through the estate, and they don't need to file a lien, right? They can collect the amount owed, and there are all kinds of very specific rules about when you can do it, if there's someone living in the house, the order of priority. It's just a very detailed process about what happens when you're dead, as opposed to basically making sure the major asset, which is the house, is not sold while the person's in the facility, right? It seems like there are two separate ways of going about this.
Yes, Your Honor, that's absolutely correct. There are two separate mechanisms for recovery that Congress has allowed states to pursue. And one is estate recovery, as you laid out, and the other is liens.
But if you do what you want, aren't you basically, you know, the word collapsing keeps coming up every argument. So collapsing the distinction, right? And you're creating a lien that goes on, particularly before 2013, for 50 years, so which will completely bollocks up the probate process.
No, Your Honor, we're not collapsing the two mechanisms for recovery, because there are instances in which MassHealth cannot recover through the estate recovery process.
Why not? That I can't figure out. Why can't you always recover through the estate process if you pay attention?
Certainly, Your Honor. So there are situations in which heirs of an estate will be incentivized not to probate an estate and just wait out the 3-year statute of limitations.
But aren't you notified when the person dies? Aren't you? You've been paying for them in that facility. Don't you get a notice saying, she died or he died?
Not always, Your Honor.
You just keep paying?
Right.
No, Your Honor, but there's different situations in which MassHealth may stop paying. It could be that the individual has been discharged from the institution and returned home.
But you're saying MassHealth doesn't know when somebody dies?
Not always, Your Honor. They do their best, but
let's just take, in this case, did you know when the decedent died?
MassHealth knew when the decedent probate was entered pursuant to the notice that's required.
So 9 years after her death, you knew that she died?
Yes, Your Honor.
Before then, you were continuing to pay for her nursing care?
Not continuing to pay for her nursing care, Your Honor.
You thought she was back home?
I'm not sure exactly there's 2.3 million people in MassHealth, Your Honor, so MassHealth.
Right, so I would think it would be a big deal for MassHealth to know when to stop paying.
Yes, Your Honor, and MassHealth does its best to keep track of this. But there are also instances where MassHealth receives notice and still does not engage in the estate recovery process. And the reason for that is because if probate is not initiated, then Mass Health has the option after 1 year to appoint a public administrator to probate the estate. But Mass Health, as a policy matter, will not appoint the public administrator if there is another individual living in the home. Because as a policy matter, Mass Health doesn't want to force the individual who's living in the home out of the house.
Well, they
With-
can't, right?
They can't, right? Yeah,
can't-
by
they can't.
statute, they have to, they can't do that.
Yes, they can, Your Honor.
Interesting.
What would happen is they would appoint the public administrator. The public administrator is required by law to resolve the estate, and if the home is the primary asset that's needed to resolve the estate, the claims against the estate, then it would be sold, and that would be used to pay the
I
creditors.
thought there's a rule that if there's like a surviving spouse or somebody in the home, you can't exercise the lien on that.
Yes, Your Honor, that is correct. 31B provides that if there's a surviving spouse, a child under the age of 21, or a blind or disabled child, that recovery cannot occur. But I'm talking about when there's another individual living in the house who's not protected from recovery. If it was forced to go to the estate recovery process, Mass Health would be forced to push that individual out of the house, and as a policy matter, they choose not to, and they can continue to protect their interest through the lien process. Additionally, Your Honor, in the instances that you were referencing where there is a protected individual in the house, Mass Health often does not appoint a public administrator because the public administrator, it would be very inefficient for them to be appointed and then to only have a claim that's deferred until that individual dies or the property is sold. So those are two instances in which Mass Health, as a practical matter, uses the lien to secure their rights to recover.
But they can't they protect themselves in the probate process without the TEFRA lien being in place? I get it. All of us are paying for this person to be taken care of. Our tax dollars are paying. You should be able to recover that. I completely get that. But I also don't see why the ordinary probate process doesn't protect you once. And also, it just seems like by collapsing those two processes, you're creating all kinds of confusion. And the idea that you can do this for 50 years. So everything's going hunky-dory. Any case, a lot of people have wills and things from 2013. They're in these homes. So you guys can do whatever you want for the next 50 years in those cases?
If the individual died before the effective date.
Doesn't that
Of the
seem crazy
MEPC.
to you?
No, Your Honor, because the legislature provided that period of limitations. And so it's what the legislature thought was appropriate. But additionally, Your Honor,
Which period of limitations, the 50?
Yes, Your Honor, that was the law in place before 2012 with the
So let me ask
MEPC.
you about Mass Health's own manual, which I think one of the judges below relied on in interpreting the lien as expiring upon the death of the beneficiary and/or the family members.
Yes, Your Honor. So I believe you're referring to the state Medicaid manual's reference to,
Yeah, which says recoveries must be made from the individual's estate after death or from the proceeds of the sale of the property on which the lien has been placed.
yes, Your Honor. And
Isn't that a clear statement of interpreting the language that you want us to interpret a different way, consistent with the way the judge here, Judge Ordonez, interpreted it?
because it requires too many inferences, Your Honor. The ordinary rule for statutory liens such as this is that they only expire upon a condition that is explicitly set out in the authorizing statute. Here, Section 34 of Chapter 118E is the authorizing statute for Mass Health to impose these liens. That section provides that Mass Health is permitted to impose liens which are allowed by the federal secretary. Those liens are laid out in Section 42 U.S.C. 1396P. That federal section only provides one condition upon which these liens dissolve, and that's a discharge from the institution and a return home.
Well, don't those provisions refer to during the life of, or they have this language that's cross-referencing the person being alive, right?
No, Your Honor. The federal statute 42 U.S.C. 1396P just says that you can impose the lien and the only condition upon which the lien dissolves is if the individual returns home. The reference to an individual's
It doesn't say only.
no,
that-
Your Honor,
I
it
guess
says
it-
unless.
Well, it says it shall dissolve when the person returns home.
That's correct.
Okay, so there may be other situations where the lien dissolves.
Yes, Your Honor,
It's
but
just that this is the one that's listed, and I guess your argument is, having listed this one, silence as to the others means that those other ways of dissolving the lien does not exist.
yes, Your Honor, because you would have to read a condition into the statute that's not there.
Does
Well,
any,
you're reading in only, I'm just, so, shame on you. But I take your argument meaning that the silence as to the other dissolution mechanisms means that this is the only one.
Yes, Your Honor, and
does either any of the federal or state statutes say that TEFRA liens survive death? Because you would think that, because we've got very precise limitations on recovery. Does anything ever say it survives death?
no, Your Honor, but you wouldn't expect it to say that it survives death, because the ordinary way that real estate and statutory liens operate, as outlined in real estate treatises and recognized by the Supreme Court, is that they continue until they're paid, discharged, or a condition occurs. And that's because the interest attaches to the property. It's not attached to the individual, it's attached to the property. So the death ordinarily does not affect a lien.
But you don't also have a separate way of recovering. Here we have a pre-death and a post-death way of recovering. So I understand normal liens, that's how you want to preserve your rights. But here you have a whole separate way of protecting with all kinds of particular rules, right?
Yes, Your Honor, but we know that the federal government, Congress, when it enacted the law to allow states to recover under these TEFRA liens, did not intend to limit it to just pre-death recovery, because we know that other states engage in post-death recovery.
Although the feds have written a guidance saying that we do the exact opposite. We don't do that. Right, you've got that policy brief from whatever the...
Yes, Your Honor. I believe you're referring to policy brief number 5. We would argue that that policy brief is a federal interpretation of state law with no citations to any authority, and so it should not be found to have any persuasive value here. It's contrary to Mass Health's interpretation of the law.
But certainly not contrary to the way Mass Health in its manual used to describe it.
I believe it is, Your Honor, because Mass Health's manual just says the estate after death. It doesn't indicate that the recovery from the lien is limited to an individual's life. There's no such express statement of that, and you would have to infer that the use of the term after death, an estate, would be meant to limit the lien recovery that's also referenced. I don't believe that that's the best interpretation of the language, Your Honor. But even if it were, the court should not rely on that language, which is only has persuasive authority. They should look to the text of Section 31D, which provides that the division is also authorized during an individual's lifetime to recover all assistance correctly provided on or after April 1st, 1995, if property against which the division has a lien is sold. But the language that the probate court and no other court which has considered this issue in Section 31D is at the end of the section. It says this subsection shall not limit the division's ability to recover from the individual's estate under subsection A or B, or as otherwise provided under any general or special law. So the probate court below read a section which says that you are also authorized during an individual's lifetime to recover. They read that to mean that the lien expires upon death, even though there's an express statement that it's not supposed to limit other recovery provided under other laws, such as Section 34. So, Your Honor, the probate court read out that section, and it also ignored some other statutory sections, such as Chapter 118E, Section 32J. That section was enacted at the same time as 31D, and it provides that a personal representative can discharge a lien against the estate through certain mechanisms. I see my time has expired.
I'm sorry, Chief, can I ask one more question? There is a second part to your argument that you haven't yet gotten to. Can I
Yes, Your
ask
Honor.
you why Judge Ordonez's interpretation of that statute of repose applying to claims against the estate is wrong? I don't really quite understand your argument. You're just saying that Kendall was about a date of death that happened after the MUPC was already in place, and our beneficiary died before then, and so we're under the old regime of 50 years.
Yes, Your Honor. As this court has recognized, the ordinary approach is that where there is no express legislative directive, the court applies the rule of interpretation that statutes operate prospectively, not retroactively. But additionally, Your Honors, the session laws which enacted the MUPC here expressly provide that if a right is acquired, extinguished, or barred upon the expiration of a prescribed period that has commenced to run under any other statute before the effective date of this act, that statute shall continue to apply to the right even if it has been superseded. So the right to recover under the pre-MUPC statute would be what's described in that section, and it's indicated that it's not.
Is there an argument that only applies to trusts?
No, Your Honor, because that section refers to the act, and the act that is at issue is an act that amended both the MUPC and the Uniform Trust Code.
The provision you're reading from just refers to trusts, right?
No, Your Honor. Actually, there's a Part A and a Part B of that provision. Part A refers to trusts, and Part B is the part that I'm referring to.
But Part B also doesn't expressly refer to the act you wanted to refer to, right? It just uses the word acts, right, generally?
Yes, Your Honor. It uses the general word act, which we argue applies to the entire act, which includes the MUPC.
Just going back to the first issue for just a second, what is it that Mass Health loses if we interpret it the way your opposing counsel wants us to interpret it, given the fact that there is another way to get the money?
Well, Your Honor, there were the examples where a personal administrator, it's not practical or good as a policy matter to appoint one, which I addressed with Justice Kafka. But additionally, Mass Health loses the security on its ability to recover post-death that it otherwise would have as a secured creditor. So if there's an instance where...
Meaning if it falls asleep and forgets to use the probate process for 8 years, we can resurrect the lien, right?
No, Your Honor. Section 32I requires Mass Health to wait 1 year before it can post-death before it can appoint a public administrator. So during that 1 year period, if the lien dissolves upon death, then Mass Health is not recognized as a creditor, and they're not being notified if the house goes into foreclosure because it's fallen behind on taxes, if there's a mortgage foreclosure, if there's a reverse mortgage foreclosure. Mass Health would lose its status as creditor during that 1 year.
Wait, I don't understand why it would lose its status as creditor. Maybe it would lose a priority that the lien gives it, but why would it not be a creditor having given the benefits to the decedent?
Because, Your Honor, if the lien dissolves upon death, Mass Health is not considered to be a creditor until it files its notice of claim in the probate court. We know this because if they don't file the notice of claim, they can't collect. They cannot file the notice of claim until probate begins. If an individual does not begin probate during that 1 year period, Mass Health is prohibited from appointing a public administrator for a whole year after the death.
But so how do they, but if that, after that year, they're completely protected, right? What could happen that would screw Mass Health out of the money during that year? I'm trying to understand that.
Certainly, Your Honor. It could be the case that the property is subject to tax liens that then are collected and the estate is foreclosed upon, and Mass Health not only doesn't have priority, sometimes they're not even noticed. It could also be something like a reverse mortgage that's collected upon.
So you've got, again, because we'll ask your opposing counsel this very question. So what's going to happen? So there's a tax foreclosure on that property, and Mass Health would somehow lose out? Is that what you're saying, that there's that possibility?
Yes, Your Honor, because if Mass Health is not, if the lien is not in place, Mass Health is not a creditor, the tax foreclosure occurs, they're not notified, and the assets from the estate are distributed, the home assets are distributed. And so by the time it gets to estate recovery, there might be nothing left for Mass Health to collect upon. Thank you very much, Your Honors. We ask you to reverse.
Okay, thank you. All right, Attorney Dupuy.
And don't forget that one, because I'd like the answer to that.
Maybe you can start with that.
Good morning, Chief Justice Budd and other justices. Matthew Dupuy for the appellee. Mass Health does not have a problem during that 1 year. Think about what the situation is. The house is in the name of Frances Mason. It's in her name, okay? She can't, the heirs can't do anything with it because has to be probated. They can't sell it. She passed away. So if the property is in her estate, it's just going to sit there.
Well, she's saying the town of Newton wants to foreclose on the house. Is that possible that they can foreclose, and without that lien, that Mass Health is left holding the bag, meaning you and me and the rest of us taxpayers are left holding the bag, or how is that prevented?
First of all, that we're talking real estate taxes, whether it's 5 or even 10,000 a year. In a situation like this, the person has passed away in the nursing home. I don't know what the situation is with the real estate, but it's not enough to come close to the value of the property. So Mass Health is not in danger. So so they are protected. So Mass Health that first year can sit back, and if no one files an estate, then they can come in month 13. They're totally protected. It's a red herring, my sister's argument.
Can I ask you one thing that does bother me directly? It's the language of 32. So they reference personal 32J. They reference the personal representative, and they reference a lien. Is this just a drafting error? Why does 32J, if there's no liens allowed, if the liens dissolve on death, what is 32J talking about?
I don't know. Is it referencing the Mass Health lien, or is it referencing all liens?
Well, it's referencing all liens in general, but I think it also makes a reference to Mass Health in that section. Do you have 32J handy?
Not real handy, Your Honor.
Okay.
Sorry about that.
All right. I'll dig up the provision. We can talk about it more expressly, but it seems like to me that if you're right, that all liens, these TEFRA liens are gone, there would be no discussion of liens in 32J and Mass Health in relation to those liens, rendering this sort of a drafting error in your view, because otherwise it would make sense to have the liens stay alive, because that would be what it's referring to.
Well, the states have the option. Mass has opted not to keep it alive.
Well, 32J is a Massachusetts statute, right?
Well, but the UPC has essentially overruled that because they want it handled in the estate, and they want it handled within 3 years. And this court wants it handled within 3 years, which is the way it should be handled.
Well, that's a separate, don't jump around yet, because
Okay.
we'll get there. But I'm just trying to, it would be really helpful if you could give us an interpretation that makes sense of this, unless it's just a drafting error. If it's a drafting error, that's okay, but it just seems nonsensical to reference it.
Yeah, I'm sorry, I can't answer that, Your Honor. I would like to talk about.
Let me just read it to you for a second. If
Sure,
the
go
personal
ahead.
representative wishes to sell or transfer any real property against which the division has filed a lien, so again, the division has filed a lien or claim, not yet enforceable because circumstances or conditions specified in Section 31 continue to exist, the division shall release the lien or claim if the personal representative agrees to blankety blank. But isn't this all unnecessary if Mass Health's lien automatically dissolve on death?
Now I understand, Your Honor. Yeah, I don't know when that statute was enacted, but liens in the real estate world, if there's a lien there, it's going to have to be dealt with. And the dissolution of the lien is only.
It's the division in which the division has filed a lien.
Division of Mass Health.
Yeah.
Right.
So, but you say all liens of Mass Health dissolve on death. If that's the case, this makes no sense, right?
Well, because my statement is 2023. And it wasn't until 2012 where we first started to look at this issue, and then Kendall, we started to look at it more closely. So it's a difference of timing. But there are liens out there today, and there's no.
But no, Kendall doesn't deal with TEFRA liens. TEFRA liens have been around for a long, long time. I mean, I understand all of your argument that the TEFRA liens are designed for the sale of the house while the person's in the institution, and there's a whole separate process to use the probate process, and you don't need a lien there. My problem is that 32J kind of makes this mushy and messy, but you're not really helping me out of telling me what 32J is talking about yet.
That's correct, Your Honor.
Okay.
So on why the lien dissolves, we look at the Wells Fargo case, which talks about the federal statute and that it's primarily to resolve the situation if the person leaves the facility. And the lien is going to be discharged at that time, or the lien's going to be paid off if the house is sold. And
Again, all that makes, I completely understand the pre-death process. You don't want people in these institutions and then the family selling the home and then the Commonwealth's left holding the bag. But why couldn't the lien survive and have it just survive and then it goes into the probate process?
it could, but Mass has elected not to do that. And many states have, but Mass has made the choice that they'd rather have the estate deal with it.
And what is the evidence of that statement?
It's the state.
Because the property goes into the estate, so
Correct.
having the lien attached to the property going into the estate still requires Mass Health to go to the estate. I guess I don't understand your argument that the lien that Mass decided and chose not to have the lien continue after the beneficiary died.
That's correct.
But what is the evidence of that? What are you relying on?
Well, the federal statute, which
So
says.
that wouldn't tell me what Massachusetts decided.
Okay. The state Medicaid manual states that it dissolves.
Where does it say that?
It's discussed in the Wells Fargo case.
Okay.
Wells Fargo found that a plain text reading of the statutory code properly disposed of the liens upon the death of a member. And further,
Which language does it rely on to do that?
it relies on, first it relied on the federal statute.
But the federal statute, I think you both agree, you could, under the federal statute, you could keep the liens alive, right? They don't preclude you from keeping it alive. A lot of states do. We just don't, you argue.
Correct. So the federal statute gives the option to the state, and then the state Medicaid manual, their policy was to go by way of the estate recovery and not use the
Can you
lien.
tell us, it would be useful if you tell us the provision in that Medicaid manual, because I'm not aware of it. I'm aware of the federal policy brief that says we don't do that, but I didn't know that we actually said it in a Medicaid manual.
It's not only in the state Medicaid manual, but it's been the mass health practice. And what's kind of
Why
ironic
don't you
here,
answer the first question before you move to practice?
Okay.
Where in the Medicaid manual does it say that? Because that would be really useful for you.
all right. That would be in the Wells Fargo case.
Yeah, but the Wells Fargo case may be just interpreting something, but again, I'll look for, you've attached the Wells Fargo case here? Have
That's
you-
correct.
Okay. And again, and is the Medicaid manual attached somewhere in here? Because,
Yes, I believe so.
okay, so it would be useful if, I would ask the chief if we could have a 16L letter that references the particular provision in the Medicaid manual that's supposedly in this record so that we don't have to dig it up, that you're talking about.
Sure. Yep. And what did you describe that as, a what?
I'm just quoting you. You said
Yes.
the Medicaid manual says that, I guess that these things do not, that the tefroliens do not survive death. That would be I know that the federal policy brief says that exact same thing, but your sister just argued that that's wrong. But if the state Medicaid manual says exactly what the federal policy brief says, that's a very helpful piece for you, and I would like to look at it. And I haven't seen it.
Okay. And do you want me to do that now, Your Honor, or you want me to?
No. 16L afterwards.
16?
It's called a 16L letter. You send us a letter after we'll argue.
Yes. Be happy to, Your Honor. So the Wells Fargo case, they follow the federal statute, state Medicaid manual, and it also talks about the mass health practice. And then Chapter 118, Section 34 that's also relevant in that it discusses the division is authorized during an individual's lifetime to recover all assistance correctly provided if the property against which the division has a lien or encumbrance under Section 34 is sold. There's no mention that it survives death. The second issue,
But it seems, again, it seems ambiguous, right? It doesn't say it survives death, nor does it say it does not survive death. It's kind of, we have to figure that out ourselves, right?
that's correct.
Right, and so I guess my question for you, following on the heels of that, is given that the default is liens usually follow property, they don't dissolve, they're not in personam, right? They're in rem. Why, given that default, would we read Section 34 to expire, to require the lien to expire upon the death of the beneficiary?
Because the way Mass handles it, the second the person dies, now we have an estate. And that's where the estate provisions come in, and Mass Health is protected. And that's the way that this state chooses to do it. And it's interesting that
Are
my
you
sister...
saying that allowing Mass Health to continue to have a lien on property that's now part of the estate would somehow I don't understand, finish my sentence. What are you saying? I mean, couldn't the property go to the estate? Mass Health continues to have a lien on it so that when the property is sold as part of the distribution of assets of the estate, Mass Health has priority because of the lien.
Well, they wouldn't have priority based upon the statutory, the 7 or 8 enumerated items, you know, post-death expenses, burial.
But couldn't they,
They live in this, they could live in the same universe. You
Right.
could still have a lien in a probate.
Yes, they could.
Right.
They
and
still could have a
it
lien.
could follow the statute and be the 5th one in priority,
Right.
right?
I
Couldn't
don't, I
it?
don't know if it'd be the 5th one. It might be further down the line.
But regardless,
Right.
it's up there.
Correct. But there's no need, when the legislature made the statute, and when they follow, and then the federal statute, which gave them the authority to do what they can do, and they have to be compliant with that. And then they have the situation where they want the fiduciary to handle it. They want the personal rep. And it's somewhat ironic, if you will, that my sister was, Mass Health has this reluctance to evict someone. Well, if they don't have to evict someone, they can reach an agreement with a person staying in the home that, all right, you can pay us in 3 or 4 years. They can essentially draft a new contract and a new lien if they want to. So it's ironic that they arguing the lien is still there, and yet they don't want to use it. So I don't, so Mass Health is basically protected. And in terms of the, my sister mentioned the incentivized, there is so many costs associated with keeping a house that that really is another red herring argument. So essentially, Mass Health is protected, and I want to talk about the retroactivity. Second
Oh
point.
dear, okay, so we're a little bit over. Does anyone have any questions about the retroactivity?
Thank you, Chief.
Is it in your brief, sir?
Yes.